Hi everyone, my name is Advocate Mehak Ahuja and today I will be talking about types of jurisdiction in India, how the courts get their cases, which case will go in which court and what is meaning of jurisdiction. This is what we are going to talk about in this video. This video is presented by the Lawyerpedia, which is the Instagram and YouTube channel. You can follow it for more such updates. What is meaning of jurisdiction? Jurisdiction is a very important topic. It means jurisdiction is the authority given to the legal body, like the court, to administer justice within the defined field of responsibility. It was explained very well in the case of Hirday Nath Roy versus Ramchandra, which explained jurisdiction in great details, and bench observed that. So I am going to state what bench observed. An examination to the cases in the books disclose numerous attempts to define the term jurisdiction, which has started to be the power to hear and determine the issues of law, the facts, the authority by which three judicial officers take cognizance of and decide cause, the authority to hear and decide a legal controversy, a power to and determine the subject matter in controversy between parties to a suit, or to adjudicate or to examine any judicial power over them, to hear or to determine and pronounce judgment on the issues before the courts, the power or authority which is conferred upon the court by the legislature to hear, determine cause between parties and to carry the judgment into effect. Then, the power to inquire into the facts, to apply the law, to pronounce the judgment, and to carry it into the execution. So, court has explained jurisdiction in such detail, like what the jurisdiction actually means, how the jurisdiction is taken into cognizance, how to decide what legal controversy will go in which matter. It depends upon the subject matter, the parties who adjudicate. So everything is explained so well in this judgment. Now, how many types of jurisdictions are there? Types of jurisdiction. In India, there are mainly five types of jurisdiction, which are territorial, subject matter, pecuniary, appellant, and original. These are the mainly type of jurisdiction in which how the court works and which court will be having which type of jurisdiction. This is what it means. So, starting with territorial jurisdiction, as the term suggests, territorial. Territorial means territory. So, it refers to the geographical boundaries limits to the court to decide a particular case. It also gives the chance of to analyze which court will be having which area case. It cannot exercise the authority beyond that territorial or geographical limit. For example, if the case was situated in Delhi, then it will only be covered in Delhi. It cannot be tried at the Bombay court. This is what the territorial jurisdiction states. Then, subject matter jurisdiction. It, as the name suggests, subject matter. It is related to the particular subject. For example, Rakesh buys the consumer good and found it to be defective. Then obviously he will go to the consumer redressal forum. He will not go to any other court, or say he will not go to the session court or any other court. He will go to the particular court, that is district consumer redressal forum. Now, this court cannot try the cases which whose jurisdiction is beyond their power of jurisdiction. That means only cases which has right to hear the cases of the particular subject, only they entertain these cases, not any other court can do. So if consumer redressal forum is made, it is made for the consumers whose contracts are breached or who has been cheated by the resellers. Likewise, In the Rakesh case, Rakesh buys the consumer goods and it was found to be defective. After several requests, seller refused to replace this item. In this case, Rakesh has right to file suit in the District Consumer Redressal Forum and not in any other court or tribunal. Here, the District Consumer Redressal Forum has the subject matter jurisdiction over the same to try this case. This is what it means. Now, other jurisdiction is pecuniary jurisdiction. Is pecuniary jurisdiction. Pecuniary means money. The court has a power to decide only the limited amount of money which the court has given sanction, which means it refers to the power of courts to decide cases that are within the monetary limits. Or, in other words, the court is maintainable in the court if its value does not exceed the monetary limits of that court. For example, if the court has power or the jurisdiction limit is 50,000, then the only cases he will refer is only of 50,000 or below 50,000. It cannot exceed the amount that is beyond 50,000. So, likewise, the Court of Civil Judge Junior Division has pecuniary jurisdiction of limit of 50,000. Hence, the court cannot try its suits whose value or the value of property is exceeding 50,000. Likewise, every court has its own pecuniary jurisdiction, its own amount is fixed in that jurisdiction. Now, other is appellate jurisdiction. So, what is appellate jurisdiction? Appellate jurisdiction is appellate means appeal. So, it refers to those appeals or the cases that are already being decided in lower courts or subordinate courts to either change them or to modify them. So it states the jurisdiction refers to the power of the court to decide the appeals of the cases that the subordinate courts have already decided. In India, both the High Courts and Supreme Courts have appellate jurisdiction to hear the matter, which are brought in the form of appeal before them. They can either overrule the judgment of the lower court or uphold it. At times, they can also modify the sentence which is being done. For example, High Court of the state has appellate jurisdiction over all the district courts of that particular state. Likewise, High Court of Delhi has the appellate jurisdiction of all the courts under district courts of the Delhi, including Tis Hazari Court, Saket Court, Rohini Court, Karkaduma Court, which all courts comes under the district courts of that particular state. The power is given to the High Court. Now, original jurisdiction. What is original jurisdiction? Original jurisdiction refers to the power of the court to take judicial note in any matter in the first instance. If the jurisdiction lies within the High Court, then the matter will directly go to the High Court. If the jurisdiction lies over the Supreme Court, that is writs or any particular matter which is to be referred to them, the matter will directly go with it. So, for example, if the family court has power to try cases related to family disputes, that is any matrimonial dispute, then it will automatically go to the family court as original jurisdiction matter. I hope you find this video helpful. Thank you, and don't forget to follow us on Instagram, that is the Lawyopedia official, for more such updates.